Okay.
Good morning. Yes, any mentioning?
For identifying the list under heading content application.
Yes, please give the number. The court is empty because of heavy rain.
Yes, my lord.
A lot of persons were stuck.
So may I call the list, my lord?
Yes, sir. Please call.
Appellate side matter. So for admission, item number 1.
Lordship, my senior Mr. Kothari has suddenly.
The microphone is bolo, microphone.
Lordship, my senior Mr. Kothari is suddenly fallen in due fever. Therefore, I pray for adjournment.
Mr. Kothari had called me up, my lord, yesterday. He's suffering from severe cough and cold. He has sought for adjournment from this statement.
But whether that compilation they have filed last.
He has already served me the compilation. That's supplementary affidavit and the original application.
Okay. When do you want it?
Preferable next Tuesday, 22 and July.
22nd July, my lord.
All right. At the request of the learned counsel for the appellant, writ petitioner, list on 22nd.
Thank you.
Grateful.
Yes.
Grateful to.
Item number 2.
May it please your lordships.
Yes, please.
Item number 2, my lord.
Okay.
My lord, this. My lord, am I audible, my lord?
Yes.
My lord, this petition is into a very short question of law, my lord. That the assessment order which was passed, my lord, it was passed ex parte without giving it. Despite myself being by present, and also, my lord, giving all the documents. My lord, if your lordship, my lord, I am registered in VAT Act, my lord. If your lordship, the registration certificate in from page number 18 onwards, my lord. Now, what happened, my lord? In 2016-17 financial year, we submitted, my lord, the fourth quarter tax, my lord, on 31st March 2017, and pursuant to that, my lord, a notice was issued for under section 66 of VAT Act, my lord, directing to produce all the documents on 14th June 2017. If your lordship kindly turns to page 34 of my petition, my lord.
Sorry for interruption. Mr. Siddiqui, why can't we send it back? Assessment order was passed on 25th of June 2019. Until date, you are not able to do. And what 72 lakhs 49,000 is the demand.
In the same year, my lord, 2019, my lord, he filed this application which was disposed of in 2025. In the same year. Since the matter was pending disposal before the learned tribunal,
we filed
and by specific instructions, my lord, we had issued the draft assessment order. We have sent them by registered post, speed post, and thereafter the assessment order was also served upon.
Assuming we uphold the decision of the tribunal, on what grounds he will file an appeal? Because his side of the submission has not been on record. It's not come on record.
He is challenging the assessment order.
Correct.
There is a statutory appeal.
That is true, sir. But his reply was not on record.
My lord, we are sorry, my lord, we cannot get you.
No, his reply to the draft assessment was not on record. His stand also was not on record. So therefore, he moved an application before the tribunal.
The learned tribunal did not venture into that arena. The learned tribunal only, my lord, since there was an alternative remedy, so relegated the petitioner before the statutory authority. But we have specific instructions that the draft assessment order and the assessment order both were served upon him.
Now, where is the draft assessment order?
Under the draft assessment order, my lord, it is, your lordship will find, my lord, my lord, in page number 37, my lord. This was the this was the assessment order. No,
Draft assessment is not
draft
annexed.
assessment order was
Not
not
annexed.
actually, my lord, served. We have specifically stated,
Ah,
my lord, we have specifically stated, and that is also, my lord, they admitted by them that they served the draft assessment order through email. Through email, my lord. That is stated in there, my lord. And my lord, this draft order,
Now, where are your ground? What are the grounds you raised before the tribunal?
my lord, the grounds, since, my lord, what happened, my lord, I would like to appraise your lordship that when, my lord, we submitted, we were called on 14th June, my lord. We were called on 14th June 2017 to, my lord, submit all the documents pursuant to a notice issued under section 66 of VAT Act. That is why, my lord, I was, my lord, kindly come to page 34, my lord. If your lordship, lordship turns to page 43, my lord, the notice was issued upon me that I would be present on 14th June 2017.
At 1:30 p.m.
My lord, kindly turn to page 36. Kindly turn to page. On that very day, my lord, we not only appeared, but also submitted all these documents. And, my lord, those documents have been received. My lord, the stamp is there.
Yes.
36, my lord, page 36. On 14th June 2017, my lord, we were absolutely there. But, my lord, subsequently, there was period of silence for 2 years. My lord, suddenly, we received, my lord, this order, my lord, on page 37, your lordship will turn, that
25th of June 2019.
yes, my lord. See, my lord, may I read, my lord? The instant dealer has been given notice for assessment for the period from such and such in terms of the provisions under section 46 related with section 66 of the WB VAT Act, hereinafter referred to as Act, but none appeared in terms of the notice issued in Form 25, and no books of account and other related documents in support thereof were produced. Hence, a draft assessment order is drawn ex parte on the basis of the information available from Impact and sent in the dealer through email on 13th June 2019. As the dealer has not given any reply to the draft order till date, the final assessment order is drawn ex parte, keeping in view of the draft assessment order. So, my lord, kindly consider, we were very much there. Also submitted all the documents.
There is no explanation why they sat tight for 2 years.
Absolutely. And, my lord, the VAT rule is absolutely categorically clear. I have sent your lordship the PDF where your lordship will find that how notice has to be served. My lord, kindly turn to rule 208. 208 rule, my lord. I have served, my lord, the PDF, my lord, online. In email, my lord, we have sent.
They will open it.
My lord, may I read?
Once again, we will give a 2 minutes time to the court.
My lord.
He will open your email.
By email to it.
It is in your lordship's email.
Such taught rules.
Let me
Just read.
West Bengal value added.
VAT rule is elaborate.
No.
Oh, it will be here.
208 rule.
I'll just read it for your lordship, my lord. It's very short, my lord. Service
I
of
can
notice
also, I can
208. Any notice which is issued under the provisions of the Act or the rules made thereunder may be served on a dealer or person by any of the following methods, namely, personally upon the addressee if present, by messenger including a courier, by email at the address.
No, where is the email?
BA.
Latest amendment.
Where it has been amendment?
2016. By email at the address as disclosed by the dealer at the time of registration or as updated online by displaying it in the dealer's profile in the website of the directorate by registered post or speed post.
My lord, we had my lord, the earlier rule where it is categorically mentioned 208C by registered post or speed
2014,
post.
No, my learned friend is perhaps not
Which one? What rule?
armed with the rules which was inserted in 2008, 2014.
No, no.
My lord, I'll tell you, Lordship, my lord, my lord,
What happened?
I'll cut short the matter. My lord,
That
the
my
assessment,
lord,
the
email-
draft assessment was made in 2019. He had produced certain documents in 2017 as fell from your Lordship. Your Lordship wants to send this matter back to the assessing authority.
My lord, that is our-
When he doesn't complete the assessment within a reasonable period, the minimum he could have done is to issue a fresh notice.
yes, my lord.
No,
What is
my lord, subject to correction, my lord, 2019 the assessment proceeding was initiated, and in 2019 itself we had sent it by mail as well as by through speed post.
All
But
right.
I did not stand in the way.
Please take down. We have heard so and so. This writ petition has been filed by the by a dealer who is registered under the provisions of the West Bengal Value Added Tax Act, hereinafter referred to as the Act, challenging the order passed by the West Bengal Taxation Tribunal in RN number 943 of 2019, dated 19/2/2025. The said application was filed by the petitioner challenging the assessment order dated 25/6/2019, passed under section 46, read with section 66 of the Act, on the ground that it was an ex parte order and no opportunity of hearing was granted to the petitioner. The learned tribunal declined to entertain the application on the ground that the writ petitioner has an effective alternate remedy by way of an appeal before the appellate authority, and accordingly relegated the petitioner to avail the appeal remedy. Aggrieved by such order, the present writ petition has been filed. As could be seen from the documents filed in this along with this stay application, the petitioner was issued a notice dated 30/5/2017 under section 66 within bracket 1 within bracket small a and within bracket small c of the Act, directing him to appear before the sales tax officer, Kasipur Charge, Group E, in person or through an authorized agent on 14/6/2017 at 1:30 p.m. and produce their books of accounts, registers and documents, and statements relating to purchase and sales of goods, semicolon, stock of goods held, semicolon, payment made and received, and receipt and delivery of goods made in the accounting period 2016-2017 to justify their claim as reflected in the returns. On receipt of such notice, the petitioner appeared in person before the said authority on the date fixed, namely 14/6/2017, and produced the purchase register, purchase part ledger, sales register, and stock statement. Though such documents were produced, the assessing authority did not proceed with the assessment nor fixed a date for personal hearing of the petitioner. After 2 long years, on 13/6/2019, it appears that a draft assessment order was drawn and sent to the petitioner through email. According to the petitioner, they have not received the draft assessment order, and the mode of service of the draft assessment order is not in accordance with Rule 208 within bracket C of the VAT rules. The assessing authority proceeded to complete the assessment ex parte on 25 by order dated 25/6/2019 stating that referring to the notice which was given earlier, that is on 30/5/2017, and alleging that none appeared in terms of the said notice which was issued to the petitioner, and no books of accounts and other related documents in support thereof were produced.
Till date, no demarcation has been done.
And no objection were given to the draft assessment order. Therefore, the proposal made in the draft assessment order was finalized and the assessment was completed. The observation made by the assessing authority stating that none appeared stating that the petitioner did not respond to the notice dated 30/5/2017 is factually incorrect, as could be seen from the reply given by the petitioner dated 14/6/2017, enclosing the relevant documents, and this has been received in the office of the assessing authority, as could be seen from the seal affixed in the said letter dated 14/6/2017. Thus, it is evidently clear that there has been gross violation of principles of natural justice. That apart, there is no explanation forthcoming on the part of the respondent authority as to why the assessment was not completed for two long years, despite the petitioner having responded to the notice dated 30/5/2017. Therefore, we are of the view that the assessment has to be redone after due opportunity to the petitioner and after opportunity of personal hearing to the petitioner, and the documents which were produced by the petitioner should be considered, their oral submission should be heard, and thereafter fresh assessment order should be passed. For the above reason, the writ petition is allowed, the order passed by the learned tribunal is set aside, and the assessment order dated 25/6/2019 is set aside, and the matter is remanded to the assessing authority with a direction to afford an opportunity of personal hearing to the petitioner/dealer, permit them to produce the documents, and also make written submissions. And after completion of the personal hearing, the assessing authority should consider the documents already produced and those that may be produced by the petitioner at the time of personal hearing, and pass a recent and speaking assessment order. The entire exercise shall be completed within a period of 6 weeks from the date of receipt of the server copy of this order. No cost.
Most obliged. Only one prayer, Milord. A line may be included, Milord, so that the notice may be served upon the petitioner through registered post, because he is a aged person.
In this age, my lord, he can share his email ID so that we
my lord,
can.
the problem is that, my lord, he is not very much conversant with this, my lord, email.
The petitioner's advocate or the accountant or consultant can share his email ID.
If it may be, my lord, served
through. The learned advocate appearing for the petitioner submitted that the petitioner is a very aged person and is not very familiar with the with computers, etc., and therefore prays that the notice of hearing may be sent through post. Considering the peculiarity of the facts, we direct the assessing authority to send a notice of hearing by speed post with acknowledgement.
Most obliged. Most obliged.
Next.
Item number 3.
And I'm for the petitioner, my lord.
Respondent, ma'am. I am for the respondent number 1 and 2. No, I am for the respondent number 1 and 2.
Yes.
The petitioner was a customs broker before the promulgation of GST Act. Then, after the GST Act, petitioner acts as a pure agent of the supplier. And the petitioner main work is as a cargo handling agents. The investigation started, petitioner, in a summon procedure, petitioner appeared before the adjudicating authority and said this kind of the job work and the cargo handling service are exempted from the supply. Then adjudication process started. In the adjudication process, it is the fault of the petitioner itself. I am not blaming anyone. they miss the letters because they are all the directors are senior citizens they are missed on all the notices and could not reply to the show cause notice. And they also could not able to make themselves appear before them adjudicating authority on the date of the hearing. So they could not produce the documents relating to the agreements with the suppliers. The agreement says that the invoices are all in the name of the suppliers. I have annexed this today I am before your lordship following to appear before them for and produce these agreements, so that there's a huge demand of these invoice values. My broker is not that the invoice values these are more than and the pre-deposit is more than 2.5 crores And today, the company is not in a position to make a pre-deposit because thus the company being non-suited. So my humble submission will is kindly give one chance to the RTP to produce the documents before the adjudicating authority. And the adjudicating authority and I can find a reply also within 7 days. This is the only humble submission before your lordship. Demand is about 22 and 22 crore 81 lakhs because these are the invoice values. Can kindly take page 60. This is the agreements. Page 60 at the agreements Kindly take page 61, Roman 3. That the may I read for your lordship, that the payment made by a pure agent on behalf of the recipient of supply has been separately indicated in the invoice issued by the pure agent to the recipient of service. So I could not able to produce those invoices and the agreements before the adjudicating authority, to enable the adjudicating authority to make the proper assessment of the in the matter,
My lord, why the read code will entertain the read, my lord? There is no violation of principle of natural justice. My lord, there is no bona fide on the part of the writ petitioner. And my lord, Biman Mukherjee, one of the, my lord, probably director of that company, was examined on summon. He admitted everything, my lord. Now, my lord, question is that, my lord, why he will be, my lord, given all this benefit now? Despite received the so-called notice, didn't file reply, didn't attend the hearing. There is no explanation why he didn't attend the hearing. My lord, what bona fide upon the petition? Then court will be floodgated with the writ petition, my lord. Every petitioner will come to your lordship, ask for that, please, my lord, kindly condone the day, and then allow me to everything, my lord. My lord, since in any event, they have to appeal at forum, my lord.
Mr. Ghosh,
yes, my lord.
On 3 dates they have given you an opportunity.
I am admitting that.
31, 31,
I'm admitting that, and I am bowed down to your lordship, kindly take order in original at page 79. Kindly take 79 and this is the internal page 8, that is at page 86. Kindly take the last paragraph. That is the version of the adjudicating authority. In this regard, value of the total outward supply, value nil-rated exempted supplies, and total ITC available during the material period had been obtained by the investigating team of the Department of GST 3B, GST 9 had been considered, and quantification of excess availment of ITC accordingly table 1 and table 2 has been prepared. So today factually I cannot controvert before the adjudicating authority without submitting the documents like the agreements. So the entire adjudicating process is without appreciation of the proper facts.
What can you do, sir? If we start interfering in these type of orders, then we will be flooded with writ petitions.
I know, this is a peculiar circumstances. They are the all are the senior citizens, and they missed out. There are misunderstandings. There are misunderstandings and the miscommunication between the lawyer and the directors. That happened. I bow down to your lordship. That happened. Today, I will be non-suited. I'll be absolutely non-suited, in this case, because there is a huge demand of the invoice value. And more than 2.5 crores, I have to deposit as a pre-deposit. I will be absolutely non-suited. So I am not before a lordship to set aside the order in original. I want a additional order after my submission of one.
It's very, very hard to believe. You were granted a customs broker license long back.
Long back, my lord. I'm 19 years, my lord. I'm working on
Then
and my lord, that is why, my lord. Before my lord, the GST regime, I'm bow down to my lord, Shriman. Before the my lord, the GST regime, my lord, there is an exempted service, my lord. Admittedly, there's an exempted service. After the GST regime, my lord, there's no exempted service. I'm acting as a pure agent, my lord. So, my lord, today, my lord, my lord, kindly give me a chance, my lord, to my lord, to produce the documents. Let the documents and the additional order be passed.
Before the appellate authority, see.
Then, my lord, I have to deposit a tip 10. Your lordship knows one judgment, my lord, very old judgment, my lord. Your lordship knows that judgment. If the my lord, that is my lord, AIR 1954. Supreme Court 403, but in the my lord, the Supreme Court says if the my lord, there's a pre-deposit or my lord, any deposit is onerous, then my lord, the alternative remedy is not a my lord, the question. I have this judgment.
It's all old law.
It's a very old matter, but not been reversed.
No, we have upheld that pre-deposit provision when sitting in courtroom number 16.
I know, my lord. I was that point of time, my lord. These kind of judgments are not placed, but may I read for lordship?
That judgment upheld by Supreme
On the
Court.
peculiar circumstances of this matter, my lord, kindly, my lord, give me one chance, my lord, on the peculiar circumstances of this matter, because my lord, then my lord, I have to, my lord, I'll be non-suited, my lord. My every account will be attached. I'll be non-suited in this matter, my lord. My lord, may I read one paragraph from the judgment, my lord?
Not required now. That is all old laws.
But that is on the
He
Bihar
himself, my learned friend himself, before the court below, my lord, he himself prayed that he wants to prefer an appeal. And my lord kindly takes up the order at impugned at page 95, my lord. He himself admitted that he making the prayer for preferring appeal.
Already
Now
I have
that
submitted,
question has
there
already
are
challenged by my
miscommunication
learned
between
friend.
the my lord,
How
advocate and the my lord director.
No,
How
which
appeal is
paragraph?
mentioned?
Which
My lord, kindly
paragraph?
page 95, kindly come, my lord, page 95 of the stay petition.
Paragraph.
My lord, paragraph, my lord, 5. Paragraph 5 of the order, impugned order, my lord.
Okay. All right. Sorry, sir. This intra-court appeal, please take down this intra-court appeal by the writ petitioner is directed against the order dated 19/5/2025 in WPA 21567 of 2024. The said writ petition was filed by the appellant challenging the order in original dated 12/4/2024 passed by the additional commissioner, Central Tax.
My lord, order date but 10th April, my lord.
Oh, sorry. 10th April 2024, passed with additional commissioners, Central Tax, CGST and CA, Kolkata South, Kolkata South. By the said order, a demand, the authority, the adjudicating authority, disallowed the input tax credit availed by the petitioner as being irregular for the period 2018-19 to TO 2021-22 under section 73(9) of the CGST Act, read with the corresponding provisions of the WBGST Act and section 20 of the IGST Act 2017. The full stop. The adjudicating authority also ordered for recovery of the excess availment of ITC, ordered recovery of the short payment of tax, and ordered to recover appropriate interest and also imposed penalty. The appellant filed the writ petition contending that adequate opportunity has not been given to the petitioner, to the appellant, and prayed that one more opportunity can be given to the appellant to go before the adjudicating authority and place their submissions so that a fresh order can be passed. The learned single bench found the submission to be not acceptable as the adjudicating authority had granted sufficient opportunity to the appellant, but despite the same, the appellant did not avail such opportunity and accordingly relegated the appellant to avail the statutory appellate remedy. Before us, Mr. Ghosh would reiterate the same submissions made before the learned writ court and contend that the pre-deposit which is required to be made to prefer a statutory appeal is a substantial amount, and the company cannot withstand, cannot afford to pay such a substantial sum towards pre-deposit, and prayed that in the peculiar facts and circumstances, the adjudication order may be set aside and the matter may be remanded to the adjudicating authority. We have heard Mr. Udeshakar Bhattacharjee, learned senior standing counsel, assisted by Mr. Ekta Singh, learned advocate appearing for the respondent department. As could be seen from the order in original, the adjudicating authority issued notices to the appellant not once but 3 times to appear before him. That is, appear before him on 17/1/2024, 31/1/2024, and 15/2/2024 to attend the personal hearing, but none appeared. Thus, it is not a case of violation of principles of natural justice, but a case where the appellant failed to utilize the opportunity granted to them. Therefore, on this ground, the appellant is not justified in seeking to bypass the statutory appellate remedy. Apart from that, the appellant has been in the business for more than 19 years, and he is not a dealer, who has registered with the department very recently, and is very well aware with the business practices, pay the statutory requirements to be complied with under the various taxation laws. It is submitted by Mr. Bhattacharjee, learned senior standing counsel, that during the course of investigation, summons was issued to one of the directors who responded to the summons, and statement has been recorded from the director who appears to have admitted the violations. If the director has responded to the summons and appeared before the authority and has given us a statement, then it defies logic that the appellant genuinely missed to avail the opportunity of personal hearing provided, that too on 3 occasions. Therefore, we find that the learned single bench was right in relegating the appellant to the to file a statutory appeal before the appellate authority, and we could find no grounds to interfere with the impugned order. Accordingly, the appeal fails and dismissed.
One indulgence,
liberty to file an appeal before the Commission of Central Tax, Appeal 1, Calcutta, and if such appeal is filed within 60 days from the date of receipt of the server copy of this order, the appeal shall server copy of the order complying with the pre-deposit condition. The appellate authority shall not reject the appeal on the ground of limitation, but shall decide the appeal on merits and in accordance with law after due opportunity to the appellant.
And my liberty may be given to my lord to submit the additional evidence before the appellate authority. Kindly, my lord.
The appellant is at liberty to produce all documents in support of that claim before the appellate authority.
I'm grateful to your lordship.
Item number 4.
I am for the respondent, my lord.
May please your lordship, my lord. The matter already came before your lordship for the consideration. Your lordship may remember that the issue is that they have disallowed the transitional credit on account of the unutilized of service tax, my lord, and on the basis of the report prepared by the Central Tax Authority. And before preparation of the report, they have not considered none of my submissions and no opportunity given, no show cause notice was issued, my lord. That was the crux of the case, my lord. And not only
whether Mr. Bhattacharjee you got instruction, because you are the answering respondent.
Yes.
My lord, what happened in this matter? He said, my lord, we have not received any brief in the matter. My lord, though my learned friend probably
this junior
from the
already
department,
present
my
here,
lord,
he
copy should
already
be given
received
to
the
us
brief,
over
my
the
lord.
Junior is there, but you Mr. Basu did not give any copy to my junior or to me, my lord.
I already
Initially, he
given
offered a copy, but
twice. I
department-
already approached
No,
you.
you
You
offered,
refused to
but
receive the
department
copy.
said that you
Then
sent
I
to the department. My
submitted
lord,
the
department
documents
did not,
before the department, my
give
lord.
me any copy, my
Under
lord.
the
This copy
instruction
should be
of
given
my
to me,
lords,
my lord, and my lord,
again I
come back-
communicated to
come
you
back
also.
on next Monday, my lord. My lord, may I?
I was not able to follow anything because both of you are talking simultaneously.
Sorry, my lord, we have not been received any brief as yet,
No,
my lord.
Mr. Basu says, Bhattacharya sir, that he has
My lord.
served twice.
Maybe, my lord, maybe. I mean, your lordship knows department, your lordship is acting such a way, the 18 months required for a year, my lord. My lord, your lordship also knows very well better than me, my lord. A copy should be given to my junior by today, Mr. Basu. My lord, we shall come back on Monday. In the meantime, we shall take instruction, my lord.
Have you got one more copy, Mr. Basu?
Yes, I make it photocopy. Even I can hand over the copy to now to his junior if he wants to do the matter. Without copy, I can do the matter even.
No. unless give any copy to me, my lord.
Where is your junior, Mr. Bhattacharya?
Mr.
My
Bhanjal
lord,
is there, my lord.
I am here, my lord.
And Bonani Bhattacharya, both are there.
And
He will also argue with those.
on Friday, my lord, I asked him if you don't receive any copy, please inform me in advance. I can send the soft copy also, the scan copy also, but Mr. Bhanjal did not inform me.
My lord, I am told that, my lord,
Friday.
my
I asked him
learned
on
friend is submitting. I have told that, my lord, he has submitted before the department. My lord, what he is submitting?
Not only that, I asked him in the court,
My lord,
sir, if you
requested
want,
to be a
I
copy.
can make a soft
We
copy.
have heard Mr. Somak Basu, learned advocate for the appellant, Mr. T.M. Siddiqui, learned senior advocate appearing for the state, and Mr. Udaya Shankar Bhattacharya, learned senior standing counsel, assisted by Mr. Tapan Banja for the respondents 2 to 5. Let one
My lord, 2 and 5, my lord. 2 and 5.
2 and 5.
Respondent number 2 and 5, my lord.
Let one more copy of the appeal papers be served on Mr. Tapan Banja, learned advocate on record for respondents 2 and 5 by tomorrow. List the matter on next Tuesday in the same time.
My lord.
Grateful, my lord. Grateful, my lord.
তুমি আমাকে জানালে না কেন?
Item number 5.
My lord, item number 5, my lord, I beg to appear virtually, my lord.
তুমি আমাকে জানাবে।
My lord, with greatest respect, my lord, learned single
I am
judge
appearing for
income
the
tax matter,
respondent
my
in
lord.
this matter. But my lord, I
Learned
wish to my
single
lord
judge, my
indicate
lord,
so
dismiss
many
the
dates are
appeal.
there.
Mr. Ray, Mr. Tilak Mitra wants to say something. Please hear.
My lord.
Yes, my lord, there are so many dates in this matter. So my lord, I have prepared a my lord, list of dates, my lord, which read to my lord, place before your lordship. If your lordship, my lord, kindly fix this matter when it can be my lord, physically possible to my lord, hand over this list.
All right, tomorrow.
Grateful, man.
Tomorrow.
My
Yes,
lord, tomorrow.
I have got no difficulties. Tomorrow.
My lord.
You have got so and so, list tomorrow under the same caption.
I'm grateful, man.
I'm grateful, my lord.
Group 6 for admission. Item number 6.
Item number 6, Lordship. In this matter, Ms. Pona Rajudri appearing before the appellant, my lord. I am praying for short passover. She has engaged in courtroom number 2, Lordship. Her matter was ongoing before the courtroom number 2. I am praying for short passover.
My lord, I appear for the writ petitioner's respondent number 1.
Also, it was adjourned. All right, we'll say not today. Today, Passover is not possible, madam. Not today.
Grateful, Lordship.
Item number 7. Nobody appears.
Not today.
Item number 8.
I am for Union of India.
All right, appellant not there.
Appellant.
So and so appears for the respondent / Union of India. List next week.
Item number 9.
Lord, I appear for the appellant, my lord. Lord, I have already served notice to them by WhatsApp. On the last occasion, Mr. Partho Ghosh did not appear.
Today also he is not appearing.
Not appearing, my lord.
All right, what is the matter?
Lord, very short matter, my lord. Territorial jurisdiction of this High Court has been in question, my lord, by the impugned order. My lord, kindly have a look at page 54, my lord. It has already been settled
by a coordinate bench dealing this matter, my lord. I mean the writ petition. My lord, may I read it out? Page 54. It was settled by the honorable court that this honorable court has the jurisdiction, but the impugned order says that no, this honorable court has no jurisdiction. My lord, may I read it out?
Page number?
Page number 54, annexure P2 of the Can 2. My lord, Mr. Islam, learned counsel appearing on behalf of the petitioner, submits that the order of penalty dated December 24, 2022 should be set aside and or quashed by the said order dated December 24, 2022 issued by the commandant BSF.
Sir, page number is not matching.
Number is not. It is annexure P2 of the Can 2. Can 2. Can 1 has already been disposed of, my lord. It was
page 52.
Yes, my lord. I'm sorry, my lord.
No, 52 is
Annexure P4.
It is annexure P4. Where is annexure P2?
Yes, my lord. Order passed by Honorable Justice Lopita Banerjee, my lord. Has your lordship got it?
No. There is annexure R1, R2, R3. Then annexure P3. P2 is missing.
Yes, my lord.
P2 is missing, sir.
P2 is the order of the honorable single bench.
Missing in the Can application.
Can 2.
Yes. Can 2, you have given a photocopy. Justice Chatterjee, he has given a photocopy of the Can. In the original Can, P2 is not there.
Okay.
What photocopy they have given?
I'm sorry, my lord.
Two photocopies not here.
Lord, may I read it out? The order date is 13/6/2023, my lord.
Yes, you please go through it.
You read.
My lord, yes. Mr. Islam, learned counsel appearing on behalf of the petitioner, submits that the order of penalty dated December 24, 2022 should be set aside and or quashed by the said order dated December 24, 2022 issued by the commandant BSF. The petitioner was found guilty for unauthorized absence and was directed to be reprimanded. 37 days of unauthorized absence was treated as dies non under Rule 25 of Central Civil Services Leave Rule 1972 as applicable to the BSF. Mr. Ghosh, Mr. Partho Ghosh, who is appearing in this bench as well. Mr. Ghosh, learned counsel appearing on behalf of the respondent, challenges the territorial jurisdiction of this court. He submits that the entire cause of action arose in Jammu and therefore the present writ petition is not maintainable before this court. Considering the submission of the parties and the materials placed on records, this court is of the view that since the petitioner underwent a surgery in West Bengal and such was the reason for unauthorized absence, this court has the territorial jurisdiction to receive, try and entertain the instant writ petition, my lord. Thereafter, direction for affidavit was passed and affidavits were exchanged. In fact, this affidavit...
Sorry for interruption, please hear. So this point was already decided.
This was decided. But kindly have a look at, my lord, impugned order. My lord, it is appearing last.
Sir, please show the order of punishment passed by the commandant. Where is that order?
My lord, order passed by the
commandant.
Authority.
Authority.
Yes, my lord. Just a second.
24th December 2022.
My lord. My lord, it is appearing at page... Just a second, my lord. Punishment order, page 50. It is single page order, my lord. May I read it out?
Yes.
My lord, it is issued by the commandant, order dated 24 December 2022. Order number such and such, Sudhan Mandal, has committed following offence as under BSF Act Section 19B without sufficient cause overstaying leave granted to him, in that he, having been granted 28 days early from 4/10/2022 to 31st October 2022, failed without sufficient cause to rejoin his unit on the expiry of the said leave, but rejoined at the headquarter 148 BNBSF on 7th December 2022. Total absence period 37 days. He has been summarily tried, my lord.
Sir, that order is not here. Page 50 is order is dated 11th July 2023.
Lord, I'm sorry for the page numbering, my lord.
No, not page numbering. What is the annexure number?
Annexure number is P16 of the writ petition. P16 of the writ petition.
Why can't you file the papers properly, sir?
My lord, I'm sorry, my lord.
P16 is not here. R3, R4, P16 is not here. P16 in can 1 or can 2?
Can 2. Can 1 has already been disposed of, my lord.
This is a big confusion.
Can 1 was allowed by your lordship.
Sorry, sir, P16 is not here.
P16 of the writ petition, my lord.
It's not here. P18 is there, 19 is there. P16 is missing.
I'm sorry, my lord.
Then we say, all right. The order which was challenged, please take down. We have heard Mr. So-and-so. None appears for the respondent. The order which was challenged in the writ petition passed by the authority dated 24 December 2022 does not find place in Can 2 of 2025. Apart from that, the order passed by the learned single bench in the writ petition at an interim stage also is not annexed in Can 2 of 2025. The learned advocate for the petitioner is directed to rectify the defects and file a fresh set of documents on the next hearing date and serve advance copy on the learned advocate appearing for the respondent. List next Wednesday.
Much obliged. Item number 10.
Lordship, I am for the appellant bank.
For the petitioner respondent.
Lordship, I am praying for not today. I am led by Mr. Pal Chaudhary. He is not present. That's why.
All right, not today.
My lord, may I pay for an intelligence? You'll also can take it up next week.
All right.
Much obliged.
Request of counsel for the appellant, list on so and so.
Much obliged.
Much obliged.
Item number 11.
In this matter, I am led by Mr. Bimal Kumar Sai for the state respondent.
I beg to appear in virtual mode, my lord.
Very good. Most welcome. And you are appearing for the appellant or respondent?
I am for the respondent, state respondent, my lord.
Appellant is not present.
My lord, Mr. Shubho Bokas Lari appearing in this matter, my lord. He is only code number 30, my lord. Kindly make it not today, my lord.
What do you say, Mr. Sai? Not today.
Grateful, sir.
He wants accommodation. Today, a lot of people couldn't travel.
That's why they are asking for accommodation, my lord.
Every road is completely blocked. BT road is blocked.
Due to traffic problem, my lord.
Heavy rains on the morning. All right, not today.
My lord, deeply obliged, my lord.
Item number 12.
Nobody is there, Mr.
Item number 13.
Well, 12, I am for the respondent, my lord.
This matter number 1 claimant, my lord. This is the workman compensation appeal, my lord.
All right, appellant is not here, not today.
I have also informed what telephone, my lord, 2 days, my lord. 2 days, but yes, I know I will appear, not appear.
But today, because of the weather condition, lot of staff also couldn't attend.
My lord, not.
Item number 13. Item number 14.
14, my lord, Mr. Rajesh Singh is appearing in this matter, my lord. In this matter, money has already been taken away through execution. All I'm praying before my lordship that let the appeal be kept pending and let the issues be framed, lordship. Let it be heard. Because on the last occasion, my lord was pleased to grant us stay till.
So the stay petition has become infructuous. So
My lord?
Stay petition has become infructuous.
My lord.
We can admit where are your substantial questions?
My lord, in my memorandum of appeal, my lord, I'm coming to that. In my memorandum of appeal, my lord, it's from paragraph number 3 onwards, ground number 3 onwards, and ground number 8, my lord will kindly see.
1 second.
This is a case of fraud also.
All right. It is submitted by the learned advocate appearing for the appellant that though stay was granted by this court, by then before the order to be communicated, the claimant has withdrawn the compensation amount deposited by resorting to execution proceedings. If that be the fact situation, that the stay application has become infructuous. Accordingly, Can 2 of 2024 is disposed of as having become infructuous. The appeal is admitted on the following questions. Question 5, question 8.
9.
9. Five, 8, and 9. That's sufficient, I think.
My lord.
Okay. Then what you should do, you should prepare an informal paper book, is it?
We shall, my lord. Let it also be heard with the appeals. My lord had fixed a number of these appeals.
On what date?
5th August, my lord.
5th August? 5th.
All right. List on 5th August along with other connected matters.
My lord, I'm deeply obliged. I'm extremely grateful.
Item number 15.
Not today.
Item number 16.
Not today.
Item number 17.
Not today.
Item number 18.
18, my lord. This is also Mr. Singh is appearing in this matter, my lord. In this matter, we have already deposited the entire awarded sum before my lord, before the Court of Learned Commissioner, my lord. I was humbly praying before my lord's lordship. We have not yet been able to serve. Lordship will kindly give us interim stay, lordship. Let us come back. Gives us 2 weeks time, my lord. Right. In the meantime, I shall serve and come back, my lord.
Fresh notice to the respondent claimants, returnable in 2 weeks. In the meantime, the amount of compensation together with interest deposited by the appellant before the commissioner, First Court Employees Compensation West Bengal, shall not be disbursed to the claimant.
I'm deeply obliged, my lord.
Item number 19.
19, my lord. I am appearing on behalf of the appellant insurance company. This is my affidavit of service, my lord. And the issues, my lord, I have prepared as my lord had directed in one of my appeals earlier on an earlier date. Yes. These are the issues, my lord.
So we will admit your appeal.
My lord. And lordship will also kindly allow me to serve upon the learned advocate appearing before the learned commissioner on behalf of the claimants, my lord.
All right. The appeal is admitted on the following questions of law. please hand over that slip, that paper.
My lord, I've handed over, my lord.
Notice sent to the respondent, claimant has been served and affidavit of service has been filed, but none appears for the respondent claimant. Therefore, liberty is granted to the learned advocate for the appellant to serve the learned advocate who appeared for the claimant before the Commissioner, Employees Compensation Court, West Bengal. As the entire compensation amount has been deposited, along with the interest has been deposited before the Commissioner, the same shall not be disbursed to the claimant till this appeal is heard and disposed of. List on the same date in August, we give a date.
I'm grateful, my lord, extremely grateful.
Item number 20.
20, my lord, in this matter also money has already been taken away through execution. I have already served, but I have not prepared the affidavit of service. My lords will pardon me for that. But
what we'll do is,
my lord,
we'll list this appeal along with the
my lord, my lord.
batch. By then you complete the service.
I'm deeply obliged. I'm deeply obliged.
When you go to the employees court, whether you will go and appear or your junior will appear.
No, the learned advocate who has appeared over there, they will be appearing.
So therefore, you ask him,
my lord,
at least 2 or 3 of them can be represented by some advocate,
my lord,
so that we can decide the matter.
My lord, my lord,
okay.
My lord. I'll instruct my clients. I'll talk to my clients so that they communicate this to the learned advocates over there. Before the learned commissioner.
You are Sucharita Paul.
I'm Sucharita Paul, my lord.
Sucharita, one more suggestion. If suppose we can decide this question, no problem. But after all, unless it is a case of a fraudulent claim,
my lord,
can we not have some sort of a settlement, like in Lok Adalat and mediation?
I appreciate, my lord. I understand.
If suppose you are on the quantum, if you can make a calculation, a suggestion.
Yes, it can be disposed of or settled. Something can be worked out.
We will answer the question.
My lord, my lord.
We will answer the question whether the concept of or principle of pay and recover would apply in a workman employee compensation under the Act. Though for MAC cases.
My
so
lord.
that we will decide. You also discuss with Mr. Rajesh Singh.
I shall.
And at least let them get some money.
My lord. After all, it's a beneficial legislation. I understand, my lord. I appreciate. I'm extremely grateful, my lord. I'll discuss.
The fraud, definitely you can test. And otherwise, if suppose some salary certificate has not been produced,
my
or
lord,
certificate has been produced, the author of the certificate has not been put in the box.
My lord.
Things, but contemporary records will be there. Some service booklet will be there.
Something has to be there.
PF receipt will be there, or the employer's ID card will be there, employee's ID card. So we can do something.
Lordship.
Okay, thank you.
I'm deeply obliged, my lord. Extremely grateful.
Well, item number 20, my lord.
Since
the execution has
already been taken away.
Then take down this order, please. It is submitted by the learned advocate for the appellant that the amount of compensation and interest which was deposited before the commissioner has been withdrawn by the claimant by filing an execution petition. Therefore, technically, the stay petition has become infructuous and accordingly the same stands disposed of. Let this appeal be tagged along with a batch of cases and listed on so-and-so date. And in the meantime, service of notice on the respondent claimant shall be completed by the appellant and affidavit of service be filed.
Grateful, my lord.
Yes. That's all, sir?
That's all.
Yes, madam. Thank you. Yes, Mr. Banerjee.
My lord, I was appearing in item number 23, my lord.
No, you will. I am not.
So my lord, it was my lord's desire that my lord, we should appear. My lord had indicated in my lord's order passed on 1st July that High Court administration should be represented.
Better.
My lord, we'll come back.
I appear on behalf of the petitioner. I appear, my lord, pursuant to my lord's directions. I have given a notice.
And Mr. Banerjee has promptly appeared.
Yes.
Next date we will take it up. Probably it will come tomorrow.
So grateful to your lordship.
I'm grateful.
Yes.
Grateful.
না আজকে নেবেন না, জজ সাহেবই নেবেন।
Matter complete, no? List is over. Yes, thank you.
Thank you, Lordship. Disconnect.